So when I'm meeting with a client initially, we're talking about how do we start our case. And we have the client get us the information so that I can understand their situation. Once I have that good understanding, we draft the initial papers. A divorce is commenced in Minnesota through the service of a summons and petition. Those initial documents, once they're served on the other party, create a responsibility for the respondent, the person getting the papers, to get either a response themselves back to me or to get counsel who's going to work with me. And there are deadlines that are established once we've started the case. We would also typically file the case with the court to get an initial case management conference. That gets us started with the court and gets us moving towards what would be the appropriate process. Typically prior to that meeting or at that meeting with the judge, we'll talk about, would this be a case for a financial neutral, someone to assist in business valuation or other assets getting valued, spousal maintenance, child support, incomes, things of that nature? Or is it a case for a social neutral, somebody to help with custody and parenting issues? The reality is that we need both parties to agree on what type of process would be appropriate in order to pick the right person and in order to try to move towards a resolution of the outstanding issues. In cases where people opt out of a mediation or an alternative dispute resolution, then we look at temporary motions, ultimately pre-trials, and in a few cases, trials.